Hi, I'm Joel Beck with the Beck Law Firm, LLC in Lawrenceville, Georgia. In just a few hours now, President-elect Joe Biden becomes President Joe Biden after he's sworn in at 12 noon. There's been some talk in the estate planning community about what that means for estate planning, estate taxes, and the like. Will the tax laws change? Will our clients need to make changes to their plans to deal with those changes? And what's the timeline of any proposed action? Well, those are all good questions. Unfortunately, right now, we really don't have all of the answers yet. Currently, individuals have a unified estate and gift exemption of $11.7 million approximately. Transfers exceeding that amount are subject to a top tax rate of 40%. With portability among married spouses, that means that a married couple can currently shield over $23 million from the federal estate tax were they to die this year. Now, under the current law, these terms are set to expire at the end of 2025, and starting January 1, 2026, it would revert back to the pre-Trump tax cuts. And that would mean a $5 million exemption per person indexed to inflation. So we can call it maybe roughly $6 million per individual, or with portability among married spouses, $12 million a couple. President-elect Biden, in his campaign, had expressed an intention to decrease an individual's federal estate tax exemption. Now, that might mean he wants to decrease it to $5 million per individual, equating to approximately $10 million per couple, or maybe down to $3.5 million per individual, or $7 million for a married couple or so. This decrease in the lifetime exemption could be coupled with an increase in the top tax rate from 40 to 45%. We're going to have to wait and see where this falls, but regardless, it's expected that relatively few families would have a federal estate tax issue even with those changes. According to the Tax Policy Center, they estimate that there will be around 4,100 federal estate tax returns filed for persons who died in 2020, but of those, less than half, maybe 1,900 or so, will be for taxable estates. Perhaps more important than the estate tax exemption amount, the Biden plan might repeal what is called the step-up in basis on death. And moreover, they might tax unrealized capital gains at the time of a decedent's death at a possibly higher rate than current capital gains tax. Now, the step-up in basis works like this. Suppose your parents bought a house for $150,000, and when they die, the home has increased in value and is now worth $300,000. The children, or whoever the heirs are that are going to inherit, they're going to inherit the house with a basis of $300,000. That embedded gain that was not yet realized by their parents as the value of their property increased from $150,000 to $300,000, that embedded gain is wiped away. There's no capital gains tax on that transfer. Or suppose somebody buys a stock at $2 a share, but when they die, it's worth $5 a share. The unrealized embedded gain of $3 per share is wiped away, and the heirs take a basis of $5 in the stock, which is the value of it when they inherited it, and they would not owe capital gains tax at the time of inheritance on the difference in market value and what their parents had bought it at. Well, here's the bottom line. We don't know what's going to happen in the future right now. While anything is theoretically possible, know this: even though estate and gift tax rates, the rate at which it's taxed, have fluctuated over the years, I believe that the actual exemption amounts have never decreased before. And prior attempts to eliminate the step-up in basis on death have not been successful so far. So what do you do? For now, I suggest plan for current laws and what we reasonably expect might happen in the future. For most people, the estate tax changes simply are not a concern, at least with respect to the exemption amount and the tax rate. But we can monitor future law changes and adjust your plan accordingly to ensure that it's optimal for your situation in light of whatever changes might come to the law. What's most important is that you have a plan in place. If you don't do your own estate planning, then you're going to have a plan imposed upon you by the government, and it may very well not match up to your wishes. And importantly, it's likely going to create more stress and have more cost to your family when you die or should you become incapacitated, as opposed to your making your own plan while you have the ability to do so. Now, if you'd like some information on estate planning here in Georgia, I invite you to visit us online at peachstatewills.com. Click on free info at the top of the web page there, and you can download for free, no strings attached, our guide to estate planning in Georgia. We'll just give us a name and an email address, and we'll send that right out to you. Again, no strings attached. Or if we can be of help to you with your estate planning questions or needs, I invite you to give us a call. You can reach us here at the firm at 678-344-5342. And if you've got other estate planning questions, send us a message. Go to Peach State Wills, send it in an email through our website, and maybe we'll be able to answer that for you in one of our other videos coming up soon. Thanks.